Morning, everybody. I'll start to mute if you haven't already. Thank you very much. We've got somebody on the... There we go. Thank you very much indeed. Lovely to see you all. Welcome to this Experts at Work webinar, which is for members of all three of our networks, as you know. We've got a very timely employment law update, and I'm ever so glad to welcome back friends of the network, Matthew Smith, partner, and Debra Gers, who is lawyer at the Blake Morgan LLP. I beg your pardon, I got your name wrong. That's terrible, isn't it? So Blake Morgan LLP, double bogey there. We've got lots to get through, as I say, so we're going to crack on. Do let us have any questions or suggestions in the chat throughout. I'll keep an eye on that. We're recording this session for our members' YouTube channel, as you know. We'll send out the link afterwards, along with the very helpful slides Matthew and Debra have kindly prepared. So pop yourselves a mute, as I say, if you haven't already. I think we're starting with Debra. Debra, over to you, and thank you ever so much for doing this.
Good morning, everybody. Thanks for inviting us along today. So I'm going to start the session looking at the Employment Rights Act 2025. Where are we now? What's on the horizon? Oh, the slides aren't moving. Why is that? Sorry, Matthew's to help. Right, okay. Sorry about that, hiccup at the start. So the session today, I've got about 35 minutes, so not a huge amount of time to go through something as vast as the Employment Rights Act. So I'm going to focus on recent implementation, so 6th and 7th April changes, and then some changes for October, the very high profile unfair dismissal changes in January 27, and then a list of what else is coming up in 2027. And very importantly, some practical steps for you to take or to think about. And you'll see that a lot of it is quite similar in really preparation and policy changes. And then I thought we'd finish off with a look at some of the resources that are available. So there are fantastic resources available, and you may be familiar with some of these already anyway. So as I say, we're going to start off with recent implementation dates. But first of all, you're probably familiar with the vast scope of the Act. Sorry, the beeps. So we've got, this is the first slide. It's a wide range of measures. So from unfair dismissal, harassment, equality at work, enforcement, trade unions, two-tier workforce, umbrella companies, vast range of measures. And the important thing is you may be familiar with some of these, and obviously some are more high profile than others. And in the time we've got today, as I say, I'm going to focus on the April and October changes and unfair dismissal. So before we start looking at the recent changes, just to, excuse me, look at the roadmap. So prior to July 2025, there was a lot of concern from businesses and organisations that they couldn't prepare for the Act. Obviously, back in 2025, it was just the Employment Rights Bill, and it was still going through Parliament and then the House of Lords. There was, in fact, a delay to it, and we had royal assent in December 2025. So until the 1st of July, we had no indication of what the implementation was going to be. And CIPD, CPI were all saying, you know, employers can't prepare until we have some information. So 1st July was the first roadmap. And that really gave an indication of what was going to come in from the day of royal assent, which we didn't know at the time, through to 2027. And one or two measures came in on the day of royal assent, 18th of December 2025, but most were going to be on a phased transition. And that was a very specific decision of the government so that employers did have time to prepare. So I've got a link to the roadmap at the end of the presentation. And it's been updated a couple of times since then, most recently just last week. And it's very important to keep an eye on the roadmap and the timelines update because some quite important measures get pushed back or brought forward. So just to give you an example, we were expecting the fire and rehire changes in October 2026, but in fact they've been pushed back to January 2027. So as I say, we do have a timeline now of what implementation we can expect. And the first thing to mention as well is the government's view to help employers was to have two specific implementation dates in the year. So the 6th of April and the 1st of October. in either year. But that's sort of slightly changed as well, and we'll have a look at that when we get to these particular measures. So before we have a look at what happened in April, I don't know if you read about this very interesting ACAS survey that was published in February. And basically, thousands of employers and employees were asked which 3 changes in the Act would have the biggest impact in their workplace. So we've just seen from the previous couple of slides, you know, the change is fire and hire, unfair dismissal, sexual harassment, 0 hours workers. So all of those massive topics. But top of the list from this ACAS survey, which I thought was very surprising, was SSP. So statutory sick pay was identified by both groups as the measure likely to have the biggest impact in that workplace. So we will have a look at these in a moment. And then secondly, both groups, so employers and employees, identified the changes to unfair dismissal. So that's the reduction in the qualifying period from 2 years to 6 months. And then we got a slight deviation there. Third for employers was the paternity leave day 1 rights. And third for employees, the changes to flexible working, where it's going to be easier to make a request for flexible working. So I was very surprised by these results, because some of these very big topics like fire and rehire, 0 hours workers, they're dominating a lot of the sort of legal analysis and comment, and they don't appear in the top 3 for either group. So it was quite an interesting survey to see what is concerning employers and employees on the ground. So SSP was top of the list, and we'll start with that for our April implementation. So from the 6th of April, employees have the right to SSP from day 1 of sickness, and that removes the previous 3-day waiting period. Lower earnings limit was removed, and employees will receive the lower of 80% of normal weekly earnings, or the fixed SSP rate, which is now 123.25. So if we explain the sort of policy background to the change, first of all, that will put into context why we have these changes. So the starting point was prior to 6th of April, if you didn't earn the lower earnings limit, which was then £125 a week, you didn't have entitlement to SSP anyway. So very, very low earners didn't have any entitlement to SSP. If they did, they would only get SSP on day 4. So for 3 days, they would get no SSP. And the problem with this was that people might go to work when they were not well. If they were at work, they might not be as productive as you'd expect. And of course, you know, risk of transmission of infection. So the government's view was, let's remove the waiting period, so people get it from day 1, and the lower earnings is now being removed completely. So we have this figure there, 80% of normal weekly earnings. That came about as a result of a consultation exercise where various percentages were considered, where people wouldn't benefit or be too disadvantaged by the actual amount. So that's the change from the 6th of April. And what employers were doing beforehand, and lots of our clients, there's just a list there of things you should be considering. Obviously, any sickness absence policies which refer to SSP, day 4 payment, you need to meet the lower earnings limit, all of that will need to be changed. And any similar references in contracts of employment need to be changed because those provisions no longer apply. Obviously, staff need to know about the changes. For employers, there's going to be higher SSP costs. The government did an analysis, and I think they estimate it was about 450 million additional costs, but per employee, it was going to only be about £15 per employee. So not a great deal, taking into account the benefits of people having access to SSP from day 1. So very important to have accurate records of sickness absence. Your payroll provider should have been notified. And if you already have 0-hour workers, agency workers, seasonal workers, you'll be used to assessing what their earnings are. But obviously you'll need to do that now with day 1 access to SSP. So that's something you need to take into account on a practical level. The other thing to mention before we look at the next measure from April was obviously a lot of the concern for employers was that, well, people will just, you know, go off sick from day one, they don't have to wait till day 4. And the obvious thing to mention as well is, you know, look at your sickness absence procedures. So people find that return to work interviews are very effective. So even with a day 1 absence, you know, if you did a return to work interview straight away, then you can review your sickness absence policies and procedures and see how effective they are and manage sickness absence. So this was a very interesting one. The employers identifying paternity leave as the 3rd biggest impact. I'm absolutely baffled by that, because actually it's a very, very modest change. So what we have, again, similar to SSP, is a day 1 right to paternity leave and parental leave. So parental leave, you needed 1 year service, and paternity leave, 26 week service. And parental leave is not the same as shared parental leave. I'm sure you know that, but just to make it clear, hardly anybody uses it. As far as I know, it's about, I think it's 18 weeks parental leave. It's unpaid, and it can be taken up until the child's 18th birthday, and nothing to do with shared parental leave. But from the 6th of April, they both became a day 1 right. So you don't need any qualifying service to take unpaid parental leave, and you don't need any qualifying service for paternity leave. You do need qualifying service, though, for statutory paternity pay. So your policy will need to reflect that, you know, it's now a day 1 right. And the other change that was introduced for paternity leave, before you could only take it, so before 6th of April, you could only take it before shared parental leave, otherwise you lost it, the 2 weeks, but now you can take it before or afterwards. So that's the other 6th of April change. And the other one, which is probably a little bit under the radar, was this new right, bereaved partners paternity leave. And basically that covers the situation where one of the carers, so usually the mother or the primary adopter, has died. And prior to 6th of April, you had no right to anything except 2 weeks paternity leave. But if the partner's now died since the 6th of April, you've got this whole access up to 52 weeks of unpaid paternity leave. And that actually started off as a private member's bill, nothing to do with the Employment Rights Act, but it's now been brought in, and it provides a right to leave if you're the bereaved partner of somebody who's died and they were the primary carer. 2 weeks leave was certainly not going to be anything like enough. So there is now this provision for bereaved partners paternity leave. So in terms of actions, again, you can see the starting point is policies. So any paternity or parental policies which refers to that qualifying period needs to be reviewed, amended. It's a day 1 right. You need to cross-refer to shared parental leave, because obviously you now need to include the fact that paternity leave can be taken before or after shared parental leave, and any template letters you have, they need to be adjusted to take account of the April changes. Again, communicated to staff. Do you need additional training for staff and managers about what the changes are? Are you going to have a separate bereaved partners paternity leave policy? The legal arrangements are actually quite complex. It's very similar, if you think, to shared parental leave, keeping in touch, notification, eligibility, rights on returning to work, terms and conditions of employment, all of those will need to be covered off in the policy. And then, of course, do you want to make any provision for paid bereaved partners paternity leave, because it's unpaid under the statutory provisions. So jumping to a completely different topic, collective redundancy. As you know, there's a risk for employers having to pay a protective award if they fail to collectively consult. So if you're making 20 or more redundancies at one establishment within 90 days, you must collectively consult. And the protective award, you'll see there from the bottom of the slide, is gross pay. So it's not capped like an unfair dismissal award, it's gross pay per employee. And a very significant change on the 6th of April was the doubling of the amount of the maximum award from 90 to 180 days. And for some employers who maybe took a risk that they wouldn't comply with collective consultation obligations and built in a sum for any risk of a protective award, there's clearly much, much less incentive to do that now because of the doubling of that award. So just to illustrate, there was a case last month, so obviously before the new change, and the total of that protective award for this company failing to collectively consult was £9 million, involved about 1,700 employees. And so if that had been a month later, they'd be looking at £18 million just for the protective award. Now, this measure is in place, so obviously you need to be aware of that from the 6th of April. And I just want to mention one other collective redundancy measure, which it doesn't come in until April 2027, and that's all about the threshold obligations. So one establishment is where the employee is going to work, but also this new measure about establishing a threshold. And we actually have a live consultation on this at the moment. And it could be a specified number of employees in a particular workplace, or a percentage, or a mix of both. And basically, the policy decision behind having this obligation is to bring more people in scope of collective consultation. But similarly, they don't want to make the threshold number too low, because then smaller organisations would be caught by it and larger organisations would be collectively consulting all the time. So it's really a balance between what's the appropriate threshold. As I say, this measure is not coming in until 2027 anyway. So if you are thinking of large-scale redundancies over the next few months, then you have to be aware of the protective award, which obviously means you need to comply with your collective consultation obligations. It's far less financially worth the risk on building in a cost for that potential award. Keep an eye out on the government response to the threshold consultation paper. And when we do have the threshold obligation kicking in 2027, if you're an organisation with multi-sites, it's going to be very, very important that you have some communication strategy in place to know what's happening across the whole organisation, not just on a particular site where an individual is working. Whistleblowing. So I'm sure you're familiar with those provisions. If you want to make a disclosure about health and safety or a criminal offence or environmental damage, you can raise a whistleblowing concern through a whistleblowing complaints procedure. And if you make a disclosure and reasonably believe it's in the public interest, to be protected from detriment, and if you're an employee, from unfair dismissal. So on the 6th of April, sexual harassment was added to that list of disclosures. So we now have an additional type of qualifying disclosure, which is sexual harassment. So very important, because it means that if you're making a disclosure, say for instance about the incidents at Harrods, do you have a reasonable belief that's in the public interest? Well, I'm sure that would be pretty easy to establish, because it's a massive organisation, it's very high profile, the numbers of individuals involved were very, very high. So that's the sort of example you can see where a sexual harassment disclosure might be made. Again, back to policies, that's your starting point. Any whistleblowing policy will now need to have this additional qualifying disclosure of sexual harassment, and obviously review the reporting mechanisms as well. And do you need additional training for staff? So do managers or people within a whistleblowing procedure who deal with complaints, do they understand what the implications are if somebody makes a disclosure about sexual harassment under a whistleblowing policy, as opposed to the grievance policy or a bullying and harassment policy? I mentioned this one because it's completely under the radar. Working time records never mentioned in the original roadmap, not even mentioned in the February roadmap. But lo and behold, on the 6th of April, new obligations came in about keeping adequate records for 6 years related to compliance with annual leave and pay. So that's not new in itself, because you've always had to keep records. But there are very specific provisions about what you need to keep records of. So annual leave, additional annual leave for irregular hours and part-year workers, pay, and any pay on conclusion of employment where there is a period of annual leave that hasn't been taken. So keep your records, obviously. So quite a bit of flexibility about how you keep them, such manner and format as you reasonably think fit. It's an offence punishable by a fine. And as I say, I'm mentioning it, not publicised at all in the roadmap or in February. So just be aware of this, came in on the 6th of April. Keep adequate records. And just, I suppose, a final point here is there's obviously been a lot of litigation about what constitutes holiday pay, what you need to include in it. So if you have any concerns in your organisation, or if people have been raising concerns, about overtime, commission, bonuses, then all of that you need to address as part of this obligation to keep the adequate records. Fair Work Agency. This was established on the 7th of April. So it really is to meet the before the 7th of April, different government bodies had responsibility for different parts of enforcement of different rights. So HMRC for minimum wage. And the Fair Work Agency is going to bring all of these together. And it'll enforce holiday pay, minimum wage. And interestingly, you'll see that it has the power to bring employment tribunal proceedings. So if an individual decides not to bring a claim, in theory, the Fair Work Agency can, if they think it's sufficiently important. And it also has power to provide legal assistance, but we don't have too much detail yet on those two. Matthew's going to mention the huge backlog at employment tribunals at the moment. And obviously, if there is this agency that's able to bring claims as well for particular individuals, then it'll be interesting to see how that's going to impact on the backlog. But for now, what we know about their priorities, this policy paper was published about 10 days ago. HMRC functions will be transferred completely in relation to minimum wage. Holiday pay enforcement is likely to be a priority from 2027. And then in that year, the FWA also needs to set out a plan about how it intends to enforce other rights. Now, all of that is great, but there is concerns about funding for the FWA. So how is it going to provide legal assistance? What resources will it have for employment tribunal claims? And obviously staffing. We know that ACAS are very, very sort of busy at the moment. Employment tribunals have massive backlogs. And if there's not sufficient funding for the FWA, it may not be very effective. So good employment records, you need to keep those and understand the FWA strategy and priorities going forward. Equality action plans, so they're voluntary as of now, but they will be mandatory in April 2027. And their sort of focus really is how to promote gender equality, to address gender pay gaps, and supporting employees going through the menopause. So you're all very familiar, if you're with a large organisation, about gender pay gap reporting. And this measure will actually introduce a requirement to publicise an equality action plan about how to promote it, because at the moment you can choose to put in a narrative about what you might do to reduce your gender pay gap, but you don't have to. So in April 2027, they will be mandatory for large employers. And usefully, we've had some guidance published on the 4th of March about the areas that the equality action plans can address. And then more recent guidance published last week about how to create the action plan, looking at 6 steps. So those would be your action points there. What actions are you going to adopt? How are you going to write your narrative? What you're going to do with your action plan? How are you going to track its effectiveness, and how to review it? And as I say, it's only voluntary now, and some of you may have been taking these steps already, but they will be mandatory in 2027. So that's April 2026, whistle-stop tour of some measures that are already in place and what you should have done. And just looking ahead to October 2026, the original roadmap said 1st October 2026, and the most recent ones now just refer to October. So we don't really know for sure if it's going to be the 1st of October, except for this one. So protection from harassment. So you'll be familiar with the 2024 new, as it was then, preventative duty to take reasonable steps to prevent sexual harassment in the course of employment and to prevent sexual harassment by third parties. So that got obviously a lot of publicity at the time. necessitated a review of sexual harassment policies. The Equality and Human Rights Commission published very extensive guidance on how to meet the reasonable steps duty, the risk assessment that you needed to carry out, the training you should provide, and so on. So that reasonable steps duty is actually going to be extended to taking all reasonable steps from the 1st of October. So that's a higher threshold for employers. And it's also going to extend the third-party harassment provisions to all the protected characteristics except marriage and civil partnership status and pregnancy. So if you just go back, the 2024 duty was only limited to prevent sexual harassment by third parties, customers, suppliers, members of the public. But the new duty in October 2026 will be all protected characteristics, save for those. And as usual, the statutory defence will be available to an employer if they can show they took reasonable steps to prevent the harassment. So that could be they rolled out training, there's an equal opportunities policy. Very often that's a very, very tricky defence for an employer to succeed with. But, you know, it is available. So tied in alongside the harassment provision, although it's a 2027 measure, will be a prohibition on NDAs. So you may have read about this already. The limitation on preventing someone from speaking up about sexual harassment or discrimination is going to be much more limited when this provision is in force. If you try to include that provision, it would make the agreement void insofar as that particular provision about non-disclosure, unless the employer has requested it for some reason. They just want an end to the matter. They don't want anything to be publicised, and they want the agreement to be completely confidential. So we have a live consultation at the moment, started just last week, and that's all about the conditions for an NDA, when you can have an accepted agreement, a cooling off period, the need for legal advice. So all of that will be implemented in 2027. Again, what should you be doing for the October changes? So reviewing and updated policies, that's your starting point. Anything which refers to reasonable steps will obviously have to now refer to all reasonable steps when this comes into force. Again, communication to staff. If you've already carried out a risk assessment for your sexual harassment, third-party sexual harassment, think about any risk assessment to cover third-party harassment across all the protected characteristics. And do you need additional training for staff and managers? Just a few points to mention for October. Two-tier workforce, so that's the two-tier code. That's to prevent two-tier workforce where people are on different terms and conditions or less favourable terms and conditions if they're private sector, public sector, and so on. And that's going to reinstate a code of practice which was withdrawn back in 2010. So tipping policy, we already have that, but it's all about consultation and reviewing your policy. And then one of these sector pay agreements, the Adult Social Care Negotiating Body regulations to establish that in October. There is a second one, which is for the education sector, staff, school support staff negotiating body, and that's gone very quiet. So we had a consultation very early on last summer, but no more information about that one. We're now through, nearly at January 2027, but very, very significant change in October is the doubling of employment tribunal time limits from 3 months to 6 months. So at the moment, there are some claims, equal pay, redundancy pay, which have a 6 months time limit, but for everything else is 3 months. And the government wants to double this. I think the concern was if you've had a very distressing termination of employment or been subject to very serious harassment, it's a very, very short time period to decide to deal with that, deal with the dismissal maybe, and then decide to bring a claim all within 3 months. So basically this is going to double the period for bringing a claim to 6 months. And of course, the downside or the concern is that this will lead to more claims. The government's view is gives you twice as much time to sort out a claim and maybe settle it with ACAS, because obviously you'll have a 6 month time period to deal with ACAS conciliation. So handle your grievances effectively, ensure your disciplinary procedures are carried out, and so Moving swiftly to January 2027, and the one that I'm sure you're all aware of is the unfair dismissal changes. So this really was probably the most publicised part of the Employment Rights Bill. So throughout the debate in Parliament, it was always day one, unfair dismissal rights. That's going to have a massive impact on claims. Employers will never be out of the Employment Tribunal. And it was a focus of the government, an absolute priority. And what happened then was there was such concern about day one unfair dismissal rights that it actually got blocked in the House of Lords. So last autumn, we had this parliamentary ping pong between the House of Lords and the House of Commons. There was no agreement. No one was able to compromise. And the whole bill was stalled because we couldn't reach any agreement about the unfair dismissal change. And in the end, it was the government that did the U-turn. So rather than have day one unfair dismissal right, they've agreed to a 6-month qualifying period. So from 2 years to 6 months, not day one. And that's going to be implemented on the 1st of January 2027. And at the bottom there, just a reminder, we already have day one unfair dismissal rights for certain types of claims, such as whistleblowing, health and safety. So no changes to those at all. Now, the other change that was literally slipped in, so there was a lot of controversy at the time, the government then decided, which had never been debated at all, to remove entirely the cap on unfair dismissal compensation. So again, that's going to be January. So the current cap of 52 weeks pay, or that maximum, that will be gone on the 1st of January as well. And it will be, it's not retrospective, so it's immediately on the 1st of January, if you have 6 months service, you will be protected from the right to be protected from unfair dismissal if you have a qualifying period. So employers are getting very concerned now. So some are saying, well, I've got a 6-month probation period. Is that too long? Should we be reducing it? Others are really tightening up on their recruitment procedures, carrying out pre-employment checks, making sure those are robust, taking up references, or to ensure that they actually recruiting the right person for the job. And that if they have a probationary period, making sure that's still long enough to assess someone's suitability for the job. An unintended consequence it's been discussed as is the removal of the compensation cap may actually encourage claims from people who would never bring them before. So the very, very highly paid senior execs who would never have brought an unfair dismissal claim. They'd have just gone for wrongful dismissal if there'd been breach of contract. But now with the removal of the cap, with the removal of the cap next January, may actually be thinking of bringing an unfair dismissal claim as well. So that could mean more unfair dismissal claims for highly paid senior execs. Trade unions, we really don't have time to cover all the masses of trade union changes, but some of those have already been in place, some in February, some in April, and some in October. And then just to finish off, what else we have in 2027, fire and rehire. So that's the restriction on making changes to terms and conditions. So that's coming in January, but we don't know the date. 0 hours is the guaranteed hours contracts, collective redundancy threshold we've mentioned, improved rights for pregnant workers, the reasonable test basically for flexible working. So basically making it easier to have a flexible working request granted, non-disclosure agreements and mandatory action plans we've mentioned, and bereavement leave. So a statutory right to bereavement leave. At the moment, we only have parental bereavement leave. And the bereavement leave will extend to miscarriage loss. So it's not just going to apply to loss after 24 weeks, which would then give you the right to parental bereavement leave, but to miscarriage loss as well. So lots to come up in 2027 as well. And then just to finish off, some resources which are worth mentioning. So we have a hub on our website devoted just to the Employment Rights Act. And that has links to all of our articles on the Act and some government resources. And then these government resources are really worth looking at. So the fact sheets are individual fact sheets on every individual measure. Some are just a couple of pages. Some, the trade union one is the longest one at 17. The consultation link takes you to all of the consultation papers, starting with the ones most recently, which was the NDA, tells you if they're open or closed. The equality action plan guidance is very, very useful because each subject matter within it has links to other guidance, so that's well worth looking at. And then we have a handy fact card, which has nothing to do with the Employment Rights Act, but it's relevant because it gives you details of the current statutory rates for SMP, minimum wage, and so on. So I would definitely recommend you to have a look at the fact sheets if you wanted more information about a particular topic, and depending on your sector, if you want to contribute to a consultation, then keep an eye on the government consultation link as well. So that's the Employment Rights Act, and now over to Matt for something completely different.
Morning, everybody. I don't think anyone looks to employment lawyers for a festival of fun, but I'm also going to try not to be a complete harbinger of doom, because I want to focus on practicalities really for dealing with AI, how best to deal with the consequences that you'll undoubtedly be seeing, and we certainly are, and the employment tribunals are sharing in our collective pain. So this slide just summarises the problem. You'll be very familiar with it. Increasingly, employees are using AI to draft very long, very complicated, all-encompassing grievances, and the result of that's obvious. It creates an unmanageable document. It's very resource-intensive to try and get through it all, and often it's accompanied by a data subject access request asking for absolutely everything for a very long period of time. So that's a pretty unhappy combination. And it reflects what I've called here on the slide a kitchen sink approach. In other words, that there's a tendency for employees to just use ChatGPT or other AI tools to complain about everything. They don't bother to focus on the key incidents or the key complaints. And equally, when you've spent a long time investigating a grievance and written a very carefully worded, very clear outcome document, employees are increasingly disinclined to read that or engage with it, and they simply ask ChatGPT or another AI tool to generate a very long, almost immediate appeal. And the problem is obvious. If you're facing that volume of information, that volume of documentation, everything grinds to a halt, and you find very quickly that line management resource, human resources, time, and actually the availability of judges and tribunals is simply insufficient to cope with the volume of documentation and information that you're being given. And of course, the other problem is that the availability and ease of use of AI may encourage more people to bring grievances in the first place, as well as making them more complicated to deal with in practice. So what does that mean? Well, I was saying to Richard, we've had the most recent update from the Employment Tribunal User Group, and it's pretty grim. There aren't enough judges in some regions. Some regions are dealing with listings for hearings in 2029. And of course, the problem is that at that point, some of your witnesses will have left. They may well not be able to remember things from now in 3 years' time. And it also means that the hearings themselves are unnecessarily long. You end up with excessive numbers of witnesses to deal with overly long claims, and the judgments take longer to write. So the picture is not a happy one. And that's before you look at the other things on that slide. So both employers and employees need to be very aware of the confidentiality and data sharing aspects of using AI. The working assumption is if you put it into a publicly available AI chatbot, you have in effect published the information, because the chatbots use the questions and the answers to learn from, and they use them to answer other people's questions. And there's been an alarming series of incidents where people have put in very personal details, for example, in a grievance about harassment or medical details, without really realizing that in effect they are sharing all of their concerns and all of the difficulties that they face with the wider world by using a publicly available chatbot. The other problems, of course, are ones that you may well already have come across. You find grievances or appeals that contain lots of legalese and cite lots of cases, some of them real, but many of them not. And also actually from jurisdictions that simply don't have any relevance to the UK. I was thinking to myself confidently that the possible use of deepfake evidence was something we could put on the back burner, as no need to worry about it straight away. But it turns out that that's not right. So the link in the slide is to a BBC News article. Admiral, the insurers, have reported a 71% increase in fraudulent insurance claims, and behind a lot of them is the use of deepfake evidence. In other words, digitally manipulated photographs or other evidence to try and bump up the value of a claim, or actually to create a claim where none existed. So that's already happening, and inevitably what's being seen by the insurers will be seen by the tribunals. And I think that the big challenge is going to be, for everybody actually, but tribunals in particular, is working out what is genuine evidence and what may have been digitally manipulated. So that's a scary thing that's already here in a way that I'd hope that it wouldn't be, and it's something you certainly need to bear in mind. So as it happens, the employment tribunals are in the vanguard of all this, and it's quite helpful, I think, to look at what they're doing, because in my view it's a really useful indication of what you as employers can do to manage the problems that I've just set out. And the document I've mentioned there, the AI guidance for judicial office holders, is really good. So it's not very long, it's very clear, and it's really helpful. And the reason I think it's worth reading is because a number of the approaches that are being recommended for judges, not just in the tribunals, but also in the court system more generally, they're really practical. And I think if you adopt a similar approach to the one recommended for judges as employers, you're unlikely to go far wrong, and you may find it's super helpful in dealing with the sort of difficult grievances and appeals that we've outlined. So the starting point is to say that the parties and the judges aren't precluded from using AI. And of course, the whole point of tribunals was that they should be a level playing field, whether people are legally represented or not. So AI can be helpful for unrepresented parties. And likewise, it's not necessarily a bad thing for a judge to be using AI, but best practice is definitely to say, I've used AI in formulating this judgment. So for example, AI is being used to some extent by judges in preliminary hearings. So it's not being used to assess the credibility of evidence or to give weight to a particular witness's account, but it is being helpfully used at preliminary hearing stages. But of course, there are pitfalls. So the Sandy Peggy case is one in relation to transgender rights and the use of shared facilities. The president of the employment tribunals for Scotland was forced to go on record and to say that the mistakes in the judgment, which included quotes that seemed to have been made up from a previous case, weren't because the judge had used AI, they were just a mistake by one of the judicial staff. And I mean, it's interesting that is already, it's already a thing. People are already saying, well, the judgment's full of holes, it must have been used, must have been created using AI, to which the answer is that sadly judgments often do contain mistakes, partly as a reflection of the pressure that judges are under to produce complex judgments in reasonably tight timescales with limited resources. But the point is that people are already alive to the fact that AI might be being used and can create problems because it doesn't necessarily accurately reflect the evidence or the case law. So the thing that's really helpful, I think, in looking at how the tribunals have approached the use of AI is this concept of the overriding objective. So this is the guiding point of principle for tribunals. They're supposed to deal with cases proportionately to the complexity and importance of the issues, to avoid delay and to save expense. That's not the only part of the overriding objective, but it's the bit that's most relevant to the workplace. Because if you translate that into dealing with a case, let's say it is AI generated, it's incredibly long, it's very complicated, it covers someone's entire work history and complains about things over a 5 or 10 year period and basically makes complaints on every conceivable level. The tribunals absolutely expect employees to focus on the really important stuff. What are you really complaining about? What's the core of your case? What claims do you say that gives rise to? And what are the key incidents that you say support your case? And that's really important because robust case management by tribunals is going to be the way to deal with AI-generated claims, but it's also going to be the way to deal with those claims before they crystallise into a tribunal claim. In other words, when you're dealing with a grievance or a disciplinary or an appeal, and you're faced with an enormous document complaining about everything, it's my view that you're quite entitled to take a similar approach to the ones that the tribunal takes, because that is going to be reflected in the hearing if you have the misfortune to find that a case is then brought. And not only that, the tribunals get properly grumpy if witness statements aren't in people's own words. Now, obviously, witness statements are often drafted with assistance from colleagues or from the legal team, but essentially they are in the individual's own words. What's happening now, of course, is that someone is using an AI tool to create a witness statement that clearly isn't in their own words. And the importance of that is that the tribunals are already saying, look, it's got to be true, it's got to be accurate, and if it's not in your own words, we will take that into account when we assess whether we think your account is true or not. So again, there's a really clear parallel with dealing with grievances or disciplinaries. And then, of course, in the tribunals, it's backed up by the fact that you sign a statement of truth in your witness statement. So if you say something, if something's in your statement because you've used an AI tool and it's not accurate, you've signed a statement to say that actually the contents is true and accurate to the best of your knowledge and belief. And that is going to directly affect the credibility of a witness. And it will be important in assessing whether or not a claim should be upheld. And of course, that stands good in a grievance or disciplinary. If you're investigating a grievance and you think that the statement that's been given to you by the complainant has been drafted by an AI tool, you're absolutely entitled to take that into account. You need to be clear when you follow your process that that's what you're going to do, and you need to give the individual an opportunity to correct their position. But I don't think there's any problem in principle with saying that you will, as part of your assessment of someone's credibility and the likelihood that their account is true, you're entitled to take into account the fact that their statement may have been AI generated or generated with the assistance of AI. There's also a contempt of court risk in the tribunal, which I won't go into. But it's worth mentioning that the tribunals, because they are quite tough on this, are already saying to people, if you ignore your obligation to focus on the key parts, keep matters proportionate, or just pursue things that clearly aren't really relevant or have no great significance, then you will be at risk on costs. Now, as you'll know, generally speaking, there is no cost award in a tribunal, win or lose. But if you conduct litigation unreasonably, that engages the tribunal's discretion to award costs. And I would be surprised if we don't see more costs award in cases where claimants have used AI, they've ignored judicial guidance to cut things down, and have just relied on AI-generated statements and submissions. And of course, if the AI has created facts that aren't true or cited cases that aren't relevant through hallucination, that is all relevant to whether the party has conducted the litigation reasonably. So I've already hinted as to what that means in practice. My view is that if you handle this fairly and you clearly document the approach you're taking, a tribunal is unlikely to criticise an employer who says to the employee, you have put in 30 pages of grievance, it covers everything you could possibly have complained about in your time with us, and you've alleged discrimination or whistleblowing or unfair dismissal or any number of other claims. I'm going to invite you to focus on the parts of your grievance which are the most significant and which you wish us to look into. And likewise, if you're doing a disciplinary investigation and you're met with a wall of AI generated responses suggesting all sorts of other avenues that you should go down as part of your disciplinary investigation, I think you're entitled to take a proportionate approach. There's already case law that says you're not required to investigate every possible avenue in a disciplinary case. And the whole point of grievances and disciplinary is that they're not court hearings, and the use of AI to turn them into something that is not appropriate. So very long submissions or lots of legalese or citing lots of case law is not appropriate in a grievance or a disciplinary or as part of an appeal. And I think as long as you're clear with your employees and as long as you record it properly, there's no problem in trying to take a proportionate approach and to narrow things down. And in fact, of course, if it goes to the tribunal, the judge is likely to be grateful that some of that filtering work has already been done at the earliest stage. So here are some other interesting things to think about. As I say, I think a requirement to focus a grievance or a decision to focus a disciplinary investigation and hearing is likely to be reasonable. The test I always apply is to say, well, how would you feel if you were if the tables were turned and it was your grievance or you were being investigated? And if it feels fair, then you're on the right lines. Is it also reasonable to require that grievances or statements are essentially an employee's own words? I think it probably is. I mean, you need to be sensible about it. And clearly there'll be some cases where people, for good reason, need AI assistance and find it helpful. So an employee, for example, who has dyslexia or who has another medical condition, which means that as a reasonable adjustment, they need to use AI. Of course, that's reasonable. Can you, as a matter of policy, refuse to deal with any AI-generated grievance? To which my answer is, well, I've heard that someone has drafted a grievance policy that says that. Personally, I think that may be a step too far, but it goes to show the steps that people are thinking about to deal with these quite tricky issues. Here's just a quick reminder of the signs that AI may have been used. The really nasty one, which we're seeing quite a lot, is that you carefully produce an outcome and within a few hours you get a very, very long appeal. That's almost certainly been AI generated. A legalistic tone or other style that's not matched to the individual. Confident statements of the law, whether they're right or wrong. Generic statements without specifics or evidence. So there's quite a lot of that going on. People describing how they've been made to feel without saying on the basis on which that's happened or why. And the inclusion of US concepts. So that is absolutely a feature, including US cases. And just occasionally and brilliantly, someone sends in a document that's still got the prompts in it, or where it says, we can't help you with this bit. And it's there in the document, and you can see that it's been generated by AI. Just in wrapping up, to say, of course, there are two sides to this. It would be wrong not to cover the ways that employers can use AI, because it can be very useful. Of course it can, but you have to be super careful about how you use it. So the confidentiality aspect of it is particularly difficult. You need to bear in mind the point I made earlier about anything you put into a publicly available chatbot is effectively published to the world, and that has significant data protection implications as well. And there are, of course, different ways of using AI. So can you use it to summarize the contents of a complex grievance? Yeah, I don't see why not. If you want to try and get your head around the most important points and the employee's refusing to do it for you, I don't see why you shouldn't, with appropriate confidentiality safeguards, use AI to do that, as long as you have read the whole thing yourself. Can you use it to write an outcome document? I would say no. I think the risk of there being inaccuracies or hallucinations is too high. And the whole point is that this is supposed to be a document that records your decision, and therefore it ought to be written by you. To respond to an employment tribunal claim, well, what employment lawyer is going to say, yes, crack on, use the AI for that, it'll do a great job. I think you could give yourself a starter for 10. I would say almost certainly you need to make sure that you run it past a lawyer, or that you're using your own knowledge and experience to make sure that the document is accurate, because once you've put it in as your pleading case, you're stuck with it. Or you have to apply to amend it, and that's something that's best avoided. And of course, AI can be used in disclosure or in due diligence exercises, but again, that comes with a pretty significant caveat on confidentiality and to make sure that you're using the right prompts so that the searches are being done properly. And there was, for example, in the Horizon inquiry about the post office, there was a problem with disclosure because, as I understand it, that the correct search terms hadn't always been used to identify documentation. And so also just to remind you that the Information Commissioner's Office has a role in this, particularly in relation to recruitment, and there's government guidance on responsible AI and recruitment, all of which you need to see against the background of what Debra has said about people using recruitment in a way that matches the risk of unfair dismissal claims from 6 months on. And in summary, I would say that for employers, secondary use, So, for example, summarize an existing document is likely to be okay, but primary use, writing your grievance outcome, writing your appeal, writing your tribunal claim is potentially problematic. So there, to finish with, are a couple of pictures of us and our contact details. I'm conscious that we're running it close for questions, but we're very happy to take some and to stay on a bit longer beyond 12 if people would like us to, because we've covered an enormous amount of material in a short space of time. So do feel free to pose us some questions if you'd like to.
Yes, thanks both. Thanks for getting through so much detail and such clarity and so quickly. Questions, as Matthew says, please do raise your hand or come in. Sophie was asking about the Fair Work Agency. Where was the new agency coming from? What was the gap identified but suggested that was needed? Was interesting.
Yes, so it is an interesting question, because the reason for it was because of all these multiple agencies involved in enforcement at the moment, Gang Masters Authority, HMRC and a couple of others. The government's policy was, let's have it all in one place. So that's easier for employees' access to support. And obviously easier for them to go to one place, so they know that this one agency is going to be enforcing, you know, a whole different group of rights responsible for different authorities at the moment, to save money as well. So access to resources all in one place to save time, and really to really push the enforcement of rights, because a big problem is with, you know, you may have rights, but if people don't know how to enforce them, or if the enforcement agencies are inadequate, you know, then they're meaningless. So that.
Oh, I think you're frozen. Matthew and Deborah, I think we've lost you. Is that much just me? No, maybe not.
So
that's
back. The policy behind it.
Sorry, you're frozen. Thank you for explaining that.
Yeah, sorry, did you hear that?
Yeah, just that you just froze at the end there. That might be just me. But we're actually just coming up to the end of the. Oh, that's probably best. Yeah, thank you very much. We're coming up to the end of the webinar. And thank you ever so much for doing that. That was so helpful. Thank you for being so thorough and getting through so much information so clearly, as I say. Matthew and Deborah, I'd just like you to stay on if you would, because I want you to see feedback. Do leave us some feedback if you will, good people, and we'll see you at the next session we're doing. Thank you ever so much for coming along.
Thank you very much.
Bye.
Slides are recording with you shortly. There we go. Oh, no.